Okay, good morning, everybody. Welcome to Practice Elevation. Welcome to April. Welcome to spring. Welcome to Special Needs Planning with Jeff Marsoci. Jeff is a friend of mine. We go back a couple of years. Jeff is an estate planning attorney. This morning he's going to be talking to us about special needs planning. Jeff is insurance friendly. Is that accurate? Is that fair?
Yeah.
We want to work with attorneys who aren't trying to undo the cases, that we bring to them. And so we really appreciate when we find somebody that can help us, help our clients, help get the deal done. So I understand he's video recording and audio recording this. I'm detracting from the presentation, so I'm going to get out of the way and turn it over to Jeff. Let's welcome Jeff today.
Thank you. All right, well, my name is Jeff Marsoci. I do life and estate planning. We've been doing that now for 18 years, which I couldn't believe it's actually been that long. But along the way, we've started developing some areas of focus where we get more and more clients, and as they see the kind of job that we're doing, they want to refer their friends. And some of those areas are planning for domestic partners, planning for special needs beneficiaries, and a little more recently, when people don't do the right thing and get their long-term care insurance in place, sometimes there's nothing left but to focus on trying to prepare for Medicaid to take over for nursing home care. So those are just some of the areas where we've developed a little bit of a focus. But today I want to talk specifically about special needs estate planning. I have a lot of clients that they get referred to us, they come in, and they're just completely confused. And that's because they have a special needs child. Maybe they've actually kind of gone through the process because their child is turning 18 and now, or they're not going to be on our health insurance, or they can be on Medicaid as their health insurance, and then suddenly there are all of these rules about what their child can own, what type of income they have to have as a level, and they can't go above it in order to qualify for Medicaid. And it becomes very confusing because everyone's saying, well, you can't leave an inheritance to your child. Well, that's not accurate. You can't leave money outright to a child. You've got to plan for it the right way. And I get a lot of misconceptions around this. Oh, well, we'll just leave everything to their older brother and they can take care of it. And that's not really the best thing to do. But the one thing you really want to do is you want to make sure you're not messing this whole thing up by preparing, growing your assets, maybe even having some good insurance in place, and then have it go to that child directly, and having everything spent out on the things that public programs are going to take care of anyway. We just want to make sure that that doesn't happen, right? Now, one of the big concepts that I have to really ingrain for my clients is you don't need money. Nobody actually needs money. Money isn't good to eat. Money isn't what you're actually covering over you in the form of a roof. What you need are the goods and services that money provides. And if you're following along on the sheet, I've actually just made that first point. No one needs money. You instead need it to provide the appropriate goods and services with it. So we just need to make sure that we have a good mechanism in place to provide those goods and services to a special needs beneficiary through estate planning. All right, so the benefit rules are very, very complicated. I'm not going to pretend to know the benefit rules for special needs children. What I know is the most stringent set of rules out there are Medicaid for nursing home care. And in a lot of cases, the asset levels are the same. If you're going to qualify for nursing home care, you can keep your residence if it's below a certain equity limit. You can keep up to $2,000 in liquid assets. And you can have a vehicle, and you can have personal effects. If someone owns anything more than that, they're not going to qualify for that Medicaid nursing home program. And I believe it's the same level for a special needs beneficiary, they can't personally own anything more than that. And I think the equity limit is somewhere around $500,000. I mean, that's not too burdensome, but still, if you're talking about several $1,000s a month in benefits that you're receiving, you need certain types of medication or certain types of care, having a house worth $510,000 with equity is just something you don't want to get involved in if you don't have to. All right, so it's those benefit rules that we really get concerned with. But you know, the clients don't need to worry about that. You don't need to worry about that. I don't actually need to worry about it if we set the plan up the right way so that the inheritance is protected. Now, one of the big things you just don't ever want to leave a direct inheritance to a special needs beneficiary. But it's fine to leave an inheritance through the right kind of trust. And that's really where we come into play, is to have the right type of trust in place. And I do hear this all the time from my clients when they first walk in. I was told I need a special needs trust. Maybe, maybe not. And when I say that, I mean a separate trust. Because a lot of times, the exact provisions that you need are already integrated into a revocable living trust that's part of your plan. So you have a special needs child. There's always that kind of overriding desire and goal for parents of special needs children to say, well, this is what we need. They're so used to prioritizing everything. We need this first, then we can talk about this, then we can talk about this. But if we don't get to this first, we can't get to this. No. We need to step back, take a look at what are their overall estate planning goals, and make sure that that overall plan takes care of their special needs beneficiary. So here are the main principles in making sure you're protecting an inheritance. Don't ever leave that direct inheritance to the beneficiary. Don't leave them any money. Well, you could leave up to $2,000. Don't do it. Well, the house is exempt and it's only worth this. We can leave them the house direct. Don't do it. Just don't do it. Well, they're going to need a car. We can leave the... Don't do it. Don't leave them anything directly. I've unfortunately had a case where I was pulled in to give a second opinion. And I saw exactly what the attorney was doing. He was just trying to be clever. I know the rules, and so here's what we're going to do. We're going to look at the rules as they are today, and we're going to leave your child exactly what the rules allow. And your child today doesn't have their own car. We can leave the house. There's no equity limit. And we can leave them $2,000. You know, he's never going to have any money. Look, he's 11. Well, 8-9 years later, both of the parents die in a car accident, and the uncle's in my office, and the rules have changed. And so that house had like $600,000 in equity in it. Well, now, what do we have to do? Well, we either have to figure out something to get rid of that house, or what we ended up having to do is take out the mortgage and spend it down and make sure that the equity line never went up above $500,000. Well, he was already 18. He had bought his own car, and you just left him another car. All right, we've got to get rid of the car and spend that money down. And they left him $2,000. You know, we had the house with extra $100,000 in equity. We had the car. The extra $2,000 was just like, the small little extra headache thrown on top of it. But all of this money had to be spent because the attorney was trying to be clever in looking at the rules. Those rules change so often. How many people here have actually gotten a printed Medicaid manual about the rules? No, I know you're not telling me the truth there. Not printed. That's right. It's online. They will never print it because the rules change that frequently. So if the rules are changing that frequently, you don't want to look at what are the exact rules. You want to look at what are the protection principles that have stayed consistent over time. And it is, don't ever leave anything directly. But what has worked then? You leave the inheritance in a trust in the hands of another trustee. Are they obligated to give any money out to that beneficiary? No. It's entirely in the trustee's discretion. If it's in a trust, it's locked up, and it's entirely up to the trustee. What are they going to provide? They can provide nothing if that's what they want. Now, obviously, are you going to pick a trustee that isn't going to give your special needs child what they need? No. But that's the principle behind it. It's got to be a trust that can't be changed in the hands of another trustee, and they have complete discretion. And that's because, again, the rules change so often. If instead of leaving the house directly to that child, they just left it in the trust, it didn't matter if it had $600,000 or $5 million in value. It wasn't owned by the beneficiary, so it wouldn't mess up their Medicaid. It wouldn't mess up any of the benefits. The trustee can give them money or not. But again, who needs money? I've only seen this happen once, and it wasn't a special needs case. It was because the minute you put $10 in the beneficiary's hand, they were out looking for drugs for $10. You had the trustee can actually set up a kind of line of credit with the grocery store, and they can go in and get foods with a no return policy. And the manager will help do that so that, all right, they're getting the food they need. Do they need to give the money to the beneficiary to buy a house or rent an apartment? No. The trust can sign the lease for that. The trust can own the townhouse. The trust can handle all of that stuff. So here you have this inheritance in the hands of a trustee doing what it's supposed to do, protecting the beneficiary, but you're not putting any money into their hands and you're not messing up their benefits. And this is really where my client, you understand. There are rules. They don't necessarily have to make sense, but there are rules. If the trustee thought it was a good idea to give the beneficiary a $10,000 entertainment center with the computer, an Xbox, Blu-ray player, big screen TV, the works, they could go down to Best Buy, buy it, give it to them, or even pay to have it installed. Great, no problem. They couldn't say, here's $10,000, go down to Best Buy and pick out your stuff. Why? Because it's cash. The end result's the same, but the rule says no cash. So you just have to do it a certain way. And if you leave it all up to the discretion of that trustee, they can work within whatever the rules are at the time. That's the way to do it. So setting up these types of provisions within a revocable living trust is actually pretty standard for what we do. We have them in the trust. As you can see, we're pretty thorough with our revocable trusts. The provisions are generally in there anyway. If a beneficiary is in a situation where they are receiving benefits and giving them an inheritance would mess that up, it automatically kicks in, and then the trustee can administer the money for them. We never know what life's going to hold for us. We don't know when bad things are going to happen. If they did, no one would have to do estate planning. And apparently 70% of the people in the country think nothing is ever going to happen to them. But I guess that's beside the point. But let me ask, how many people here are familiar with the revocable living trust and how it works? This is a real new group. Okay. How many people have heard of the last will and testament? All right, so everybody's heard of that. That's generally what attorneys kind of put out there is this is what you do. It's, if I die, here's where I want my stuff to go. Well, a way to avoid the whole probate process, which is, all right, the court gets the will, they say this is where everything goes, you've got an executor, you start collecting stuff, but we want inventories for everything, we want copies of canceled checks, we want all this other stuff, and 6 months to a year and a half later, maybe this whole thing will be wrapped up and everything goes where it's supposed to go. How many people would love to do the court process stuff? Well, I don't care, I get paid, and I actually get paid pretty well to do it. But I'd rather help my clients avoid all of that stuff. And a way to avoid that is, instead of using the will as the main who gets what vehicle, we use a revocable living trust. And all that really is you're setting up a trust. I'm the trustor, I'm setting up my trust. I'm naming myself as the trustee, and I have my contingent trustees all set up. And it says, when I die, here's where my stuff goes. But now, I'm putting my assets in the trust, or I'm setting up beneficiary designations to either go in the trust or somewhere else to avoid probate. Because what is probate? It grabs a hold of anything that is still legally in a deceased person's name. They churn it through that meat grinder and have all those inventories filled out. And then it comes out the other end, it gets retitled into the correct beneficiary's name. Well, if my house is in my name of my living trust, does it have to go through probate? No. What if all of my mutual funds and investments, what if they're in my living trust? Does that have to go through probate? No. Anything that's in the trust, or I'm sure you know, is set up by beneficiary designation, it bypasses that probate process. We've actually got a book, if you want to know a little bit more about that, The Anti-Probate Revolution. If you want to get into the real technical stuff, if you really want to learn more about it, there's a really great book out there. It's a little old, but still good, called The Living Trust by Henry W. Apps III, ABTS. That's the book I read when I was in law school, and my grandmother was calling me with all of these absurd questions. I can't call the attorney because he bills me every time I get on the phone with him. Can you look this up for me? So I found this book as a way to avoid stuff. You know, when you're an attorney, or even when you're in law school, a 400-page book, that's nothing. That's light reading for a law student or for an attorney. I couldn't understand why my clients didn't want to read that book. So I eventually had to go and write this one because it's only about 80 pages and it's a lot less. So they're willing to read that. It's actually required reading for clients when they want to come in and meet with me. So if you want a little bit more about that, you can have that book. Was there a question?
What was the name of the book that you read in college?
The Living Trust. Henry W. Apps III, ABTS.
Thank you.
You're welcome. All right, so you can actually set up this plan to avoid probate for your whole estate, and those special needs provisions are right in there. Well, why do you hear, oh, you need a separate special needs trust? In a lot of cases, you don't. All right, so I guess just to make sure we're following along, point 3, all of the proper special needs provisions for most situations are already incorporated into a good revocable living trust. All right, so when do you need a separate special needs trust? Really, it's only if someone else wants to leave your child something. If they don't want to leave it to you, they want to leave it to your child instead, you want them to leave it to a separate special needs trust. They could leave it to you. It then goes into your living trust and then would eventually filter down. But I've seen a lot of problems where maybe grandma or grandpa leaves $20,000 to their grandchild with autism, and it just totally wreaks havoc with their benefits. Was there another question?
No,
That was it. Yeah, the grandparents, aunts and uncles, people want to help. You always want to make sure they're doing it the right way. So you can set up a separate special needs trust if others want to leave an inheritance. The other situation is if you want to shift money to the special needs child or to their trust during life as part of a gifting program, well, you can do that through a separate special needs trust, and it's never really getting into their hands, but it's helping you decrease your estate. Now, the estate tax limits ended up getting much, much better for people in North Carolina, so I'm not seeing gifting as much. I have a few clients who do have more than $5 million themselves, or more than $10 million for a couple. And with North Carolina getting rid of its estate tax, the planning just got a lot easier, but still there is that gifting option to a special needs beneficiary if you're doing it to the separate special needs trust. So that's still something that's out there. And how many people expect that the estate tax rules are going to stay the same for the rest of your career? Nothing is ever guaranteed, especially when you've got a lot of red ink in the federal government's budget. Anything is open to being changed. So we want to make sure that we're putting together the right pieces for the most tax efficient method of getting things to the next generation, or in trust for the next generation. And if the numbers go down, we're already set. If they stay where they are, or the limits keep getting better, well, great. With the provisions we put in, it's better to have it and not need it than to need it and not have it. Yes?
In terms of the voluntary gifting of special needs for another individual, does it matter from a perspective of locality? So let's say the child is in another state and the grandparents, so to speak, a relative, whoever it is, listening, or vice versa. Does that matter?
Usually when I get a tax question like that, I'm happy to just kick it over to the accountants, but I'll tell you what I think it is. The gift tax is on the giver. It's not on a recipient. So it wouldn't matter if, I'm going to pick on New Jersey just because I know they still have the lowest estate tax limit. It wouldn't surprise me if they've got a high state level gift tax. If the child is in New Jersey but the grandparents are here, there is no North Carolina gift tax. And federally, as long as you're keeping the gifts to below $14,000 per year, per giver, per recipient, then you're okay. If the grandparents were in New Jersey and the grandchild was here, and say New Jersey had a $10,000 limit and they gave $14,000, well, maybe they've got some gift taxes at the state level in New Jersey. But that's something to look up, and please, if you've got those specific questions, talk to the CPAs. They know a lot more about this stuff than I do. All right, now, there is a very specific situation where even in a state like New Jersey that has a very low threshold for estate taxes, where you can be of an extraordinary benefit to clients who have a special needs child, and we do this separate special needs trust. What if the grandparents want to gift, the maximum they can? Two grandparents, $28,000 a year to the special needs child. Is $28,000 a year going into a special needs trust pretty good? Yeah. What if instead that could fund a $5 million second to die policy? Well, now that's actually that's a lot better, isn't it? So maybe having the special needs trust set up just like an irrevocable life insurance trust. Are you familiar with irrevocable life insurance trust? Please raise your hand if you are. Okay. With an irrevocable life insurance trust, it's kind of like the special needs trust. It's set up. You have a trustee in charge of it who isn't the person putting the money in. You have the money going into the trust. The trustee collects it. There's some paperwork. I really don't want to get into the technical aspects of it. If you want to know more about it, just let me know. I did a white paper on how irrevocable life insurance trusts are. And I guess it's not technically a white paper. It's not that technical. It's designed for my clients to read it. So it's just a good overview. So the money goes in, paperwork is done, and then the trustee says, well, I have to invest this money. What am I going to invest it in? Okay, it's the premiums. then next year, same thing, process happens until there's the death, and now the payout of the life insurance is now in here. And bang, we've got $5 million to benefit the special needs child, still held in the trust, still restricted. But because we did it this way, instead of the grandparents owning the policy, that whole payout is now estate tax free. It doesn't count towards their estate tax. So as the economy starts to improve and we get some more people gaining and accumulating money, that $10 million mark may not be so out of reach when you start looking at compound interest 10, 15, 20 years down the road. So do they want to have $5 million put on their estate tax form if they can do it this way instead? No. So we can use this separate special needs trust the same exact way we would an irrevocable life insurance trust. So really, point number 5, often a separate trust can be used to supercharge an inheritance for a special needs beneficiary by buying life insurance. Well, any type of life insurance through the trust.
New York